Good evening, friends. Let's just wait for a minute for the participants to join in. What a day. What a pleasure it is to be hosting legal luminary Mr. Arvind Datar on this webinar. Just setting a quick context before I hand over the mic to Datar, sir. Betting, gambling, game of skill, or game of chance. Does that nomenclature change whether an online game like Rummy amounts to a bet or a gamble? The Supreme Court in Gameskraft was called upon to adjudicate this high stakes controversy, and not for the first time. From RMDC 1, RMDC 2, Chamar Bagwala to Lakshmanan, the apex court time and again weighed in on this controversy over the last 6 decades. Well, this time the dice has rolled in revenue's favor, and the online gaming industry that was already reeling from a just imposed de facto government ban is virtually on the ropes. No pun intended. Last week, we heard Revenue Council ASG N. Venkatraman's take on this judgment. Today, we are delighted to be hosting Senior Advocate Arvind Datar, a legal constitutional titan, and among the lead counsels who appeared in the online gaming batch. Datar sir, one of the stalwarts of the bar at Supreme Court, specializes across a gamut of laws, especially constitution and commercial laws. His contribution to the development of jurisprudence in these areas, especially over the last 4 decades of his legal practice, cannot be overstated. Apart from being a successful lawyer, Mr. Datar is also a prolific author. I'll just name some of the books which he has authored and revised. Central Excise Commentary, 1988, first edition. Datar sir wrote this for 7 editions on a trot. Then Central Excise Procedures. Datar sir was also chief editor for Ramaya's Companies Act, 15 years, an iconic book. Mr. Datar has written a best-selling commentary on the Constitution, which will now be in its third edition. Its release is being eagerly awaited. I am told it's just a few months away. And of course, for the last 3 editions, Datta sir has been revising Kanga and Palkiwala, the tax commentary that all of us have been referring again for more than 5 to 6 decades. This judgment is why we requested Datar sir to address this webinar. The Gameskraft judgment has huge repercussions, not only on the tax side, the tax liability side, the retrospectivity side, the precedential side, but also some key constitutional questions, especially with relating to some of the judgments that I just referred to. I'm sure Datar sir will take us through them and illuminate us as to what is the taxpayer's point of view, what is his point of view on what law ratio that the Supreme Court has laid down in Gamescraft. I know there will be questions. There are already 4 or 5 questions that I can see even before Data sir has commenced his address. What I request is please post your questions in the Q&A box. I'll try to get some of them answered from Datar sir, time permitting. It's an absolute pleasure to be hosting someone of the seniority of Datar sir. What a pleasure, sir, it is to be welcoming you to this webinar. Over to you, sir.
Thank you, Arun. Thanks to Anjur also. I must thank Sutra for arranging this webinar. When the judgment came, I told Arun that earlier also, when an important judgment comes, it is better to get the viewpoints of both sides so that, and this is basically in the interest of critical analysis of a judgment. It is work of a student of law. We have to examine what are the points held by the judgment, what repercussions it will have, what will be the change in law that this judgment will entail. What I've done is I'll be speaking on the online gaming issue. It concerns 2 judgments which were delivered on the same day. One was called Jungly Games and one was Gameskraft. I'll briefly deal with these aspects. What I've done is I have made a few slides and I'll ask Anjur to put up the slides so that the audience can follow what exactly I'm trying to say. And since it's a technical subject, maybe the slides will help you to appreciate what is the controversy and what my critical analysis of the judgment is. Now, there are two basic parts. One was the banning of all online games by the state of Tamil Nadu and by the state of Karnataka. This was challenged first in the Madras High Court, and in an elaborate judgment, the Madras High Court struck down the act to the extent it sought to ban games of skill. It pointed out that a game of skill is a business activity. It is protected by 19(1)(g), and you cannot totally ban it. You can certainly regulate it, but it cannot be banned. Subsequently, the Karnataka High Court followed the Madras High Court judgment, and the Karnataka Act also was struck down. Now, against these two judgments, the state governments, respective state governments, went on appeal. The appeal was pending. There was no stay. To make the narration complete, the Tamil Nadu government passed one more law, and they made a schedule of games which were banned. They also regulated that you can't have a game between midnight to 5 p.m. and so on, 5 a.m. That law also was partly struck down, where they said that you can't ban game of skill. This matter was pending in the Supreme Court. Now, the other branch of litigation came from the central GST, from the CGST Act, where show cause notices were issued, wherein the demands were of an astronomical order. I may also add that before this writ petition came in the context of GST, there were PILs filed in different courts saying that online games are bad, they are res extra commercial, they are harming society, and so on. And I think 8 or 9 judgments, the court said that, look, online games of skill are perfectly valid, and most of these writ petitions were dismissed. I'm not dealing with those because for lack of time. I'll confine myself to these two issues. Now, in the Gameskraft, in the GST issue, what the main issue was, what the department did was, it invoked Rule 31A, sub-rule 3, which said that you have to pay GST at 20% on 100% of the bet value. Now, suppose I join an online game, let's say Dream 11, or I play Bridge, or I play Rummy. I first put 1,000 rupees. The platform fee of 10% is tax. And I play the game. I win some money. I play another game. Now, when I redeploy my winnings, again, tax was at 28%. So it became a tax of 28% on every bet, which ultimately led to demands running into thousands of crores, literally thousands of crores. So you'd have a company which turnover was about 800 crores, but the tax demand would be something like 20,000 crores, astronomically large sums of money. All these show cause notices were challenged first before the Karnataka High Court. The Karnataka High Court quashed some of these show cause notices. And against the single judge, directly an SLP was filed. They didn't go to the division bench. They went straight to the Supreme Court, and the matter was pending. When the CGST cases started, the court took the view that, look, it is better to decide the validity also, and thus both the cases were clubbed. So arguments were made on the validity of the Act and also on the GST provisions. Now, what I'll do is, as far as today's talk is concerned, the Supreme Court has reversed the judgments of the Madras High Court and the Karnataka High Court on the ground that once there is a stake and there is an uncertain outcome, it amounts to gambling. So they have, as I'll explain later, they have said that any stake, whether it is skill or chance, will result in gambling, and the Madras and Karnataka views are not correct. I'll discuss that viewpoint. And as far as the CGST is concerned, they have upheld all the provisions. And in particular, they have said that the Rule 31B will apply retrospectively. They have said that these amendments are valid, they are clarificatory, they will apply from early days, and all SSCs have been asked to reply to the show cause notice and so on. So that will go on its own stream. So now we have to discuss in two compartments. One is on the issue of constitutionality, and the other is on the, so far as CGST is concerned, I'm only going to confine myself whether it is correct to say that these laws can be retrospective, because otherwise it will take too much time to discuss other issues. I'm particularly taking the constitutional issue because it has far-reaching consequences on constitutional interpretation, on the binding nature of precedents, and so on. So let us straight away start with entry 34 of the Constitution in list 2 says betting and gambling. It's a state subject. Only the states can regulate betting and gambling activity. The central government cannot do so. And entry 62 is the corresponding taxing provision. As you know, in the Constitution, there are general entries and there are corresponding tax entries. So entry 34 is the entry for betting and gambling, and entry 62 is the corresponding entry for taxes on betting and gambling. Now, the question is, what is betting and gambling? For a very, very long time, the settled law from 1855 is that participating in a game of skill, including placing a bet, will not be gambling. In fact, as early as 1867, Section 14 of the Public Gambling Act specifically is provided that if it's a game of skill, then that does not amount to gambling. This is the law which is there from 1867. And if you see all the police acts have consistently pointed out that if it is a game of skill, then it will not be gambling. There's no question of prosecuting anybody if he's playing a game of skill. In fact, 1867, the Act Section 12 says, nothing in this Act shall apply to any game of mere skill wherever played. And this you will find throughout. So consistently, the provision was that if it's a game of skill, then it can't be treated as gambling. Even if you place a bet, then it doesn't really amount to gambling. Now, see what is the Supreme Court said that that view is not correct anymore. And they gave 4 reasons, and I'll request them to take slide 2 now. And just, yeah. In the Jungli games, the High Court decisions were reversed on mainly 4 main reasons, and I'll discuss them one by one. First was the issue of Constituent Assembly debates. The Supreme Court refers to the debates which took place in the Constituent Assembly, where they pointed out the evils of gambling and so on. And there's no discussion on a difference between game of skill and game of chance. The members merely highlighted what are the difficulties and dangers of gambling and so on, and the need to regulate it. There is an observation that even in a game like Rummy, if very high stakes are involved, it will bring people to ruin and things like that. Now, my main submission is that a Constituent Assembly debate is an aid to interpretation, no doubt. One can find out where there is ambiguity to understand what was the intention initially. But once a particular entry has been interpreted by the Supreme Court, then in terms of Article 141, the view taken in the Supreme Court judgment will prevail over any Constituent Assembly debates. So these debates have got very limited utility, only where we are discussing a place where the law is not certain or it is unknown. Therefore, we start going into Constituent Assembly debates. So in my humble view, the reference to the debates was not necessary because entry 34, as I will shortly explain, has always been construed to exclude games of skill, and nothing in the Constituent Assembly debates can override such a view. The second view taken by the Supreme Court was that entries in Schedule 7 have to be construed liberally. There is absolutely no quarrel with this proposition. Entry has to be construed liberally. But once it is construed in a particular manner, then that decision will have to be followed unless it is reversed by a larger bench or unless there is some other factor which requires a reconsideration of the view. Now, the question is, what was the view taken in the context of betting and gambling in RMDC 1 and RMDC 2? And I'll take some time to mention these two cases because they're very critical to what we are first holding. The Supreme Court said that neither the first RMDC 1, RMDC 2 will apply because they did not discuss the scope of betting and gambling, and the fact situation was different. So now it's interesting to know what is this RMDC 1 and RMDC 2. RMDC is the name of a gentleman called RMD Chamarbagwala. Chamarbagwala was a person who was first running a football pool competition. The facts are interesting. He applied for a license in Bombay, and I remind you in 1947-48, the license was 1 lakh per year, which is an astronomical amount of money. And he got a license to run the football pool competition. Then he decided to run prize competitions. He did not get the license in Bombay. So he went to Mysore and set up the prize competitions. He started running a newspaper where the crossword prizes were being conducted. He got a license in Mysore. Now he started selling these papers in Bombay, and the Bombay law prohibited lotteries and prize competitions. And prize competition include crossword prizes, the picture prizes, single word proceedings, and so on and so forth. Initially, the Bombay law said that it will apply only to newspapers published in Mumbai. It will not apply to newspapers published elsewhere. That was 48. Now in 1952, that's where the controversy starts. The Bombay government at that time amended the law. They defined betting and gambling in 2D. They amended the definition of prize competitions in section 2, subsection D. And they said that it will apply to any newspaper published anywhere. So if that newspaper is sold in Bombay, it will be subject to tax. And 12A levied a tax on the company, on RMDC company, on the company of Mr. Chamarbagwala, which was running the prize competitions. He challenged it before the single judge. And what the single judge held was that these prize, section 2D was prize competition. The nature of the competition was purely of chance because there were 3 categories. One was a crossword puzzle, a picture puzzle, 4 different kinds of puzzles, where the solution was decided by the promoter of the company. So solution was decided beforehand. So the court held that if the solution is already known, then it's just a question of guessing which is the correct answer. So they said your prize competition in clause A and clause C is pure game of chance. Now, there was a second clause which has been discussed in the Supreme Court judgment, which said that deciding or giving a view on a future event. This is a case where people say whether X football team will win or Y football team will win. That's all. There is no fantasy game on, just a mere forecast of what will happen in future. They will say whether it rains or not. There could be a game like that. So forecasting any future event would be there. Now, most importantly, RMDC 1, the first RMDC, which I'm talking about, which is this case which came from Mysore and so on, there the law was clearly established that this particular act did not want to deal with games of skill. They said the prize competition, which is the subject matter of it's called Bombay Lottery and Prize Competitions Control and Tax Act, applied only to games of chance and not to games of skill. In fact, if you read the judgment of Chief Justice Das, throughout he refers to participants as gamblers. He said the gamblers do this, the gamblers do that, and so on. So it was all along understood that this definition applies only to games of chance and nothing to do games of skill. There are categorical findings that games of skill are not intended to be taxed at all. Now, what happened in this case? In the Bombay High Court, it was held by Chief Justice Chagla that the Act pertains to entry 34 of List 2. So the scope of entry 34 was very much under consideration in RNDC 1. But interestingly, what Justice Chagla held was that the tax on betting and gambling cannot be levied on the company which conducts the competition. He said a tax under entry 62 of List 2 will only be on the gambler and cannot be on the company. So he said, as far as the company is concerned, it is carrying on a trade. The person participating is betting and gambling. And therefore, even if the law is relating to entry 34, tax can only be under entry 60, which is a tax on trade, business, and calling. Now, the interesting part is under entry 60 of List 2, a tax on trade had a ceiling limit. The tax at that time could not be more than 250 rupees per year. The idea was, if you put a higher tax, it will become a tax on the trade and again one more tax on the income. So they put a ceiling limit of 20. So Chagla said, he struck down the law on the ground that it amounts to violation of Article 276 because the quantum of tax was more than the limit. So here was a case where the High Court said, yes, this is betting and gambling, but taxation is under entry, not under 62, but under entry 60. It went to Supreme Court. Supreme Court reversed the view of Chagla insofar as tax on betting and gambling on entry 62 is concerned. Justice Das said the Bombay government is competent to levy tax on the promoter of the game, on the game of chance. They can always levy it on him, and he is entitled to pass it on to the gambler, as he called it, and there is nothing wrong with it. And the question was the scope of 19(1)(g). So one issue was this law related to betting and gambling. Tax also could be on betting and gambling. Now the next question was the scope of 19(1)(g). Interestingly, one argument addressed was that why do you call it a trade business? Because they said that the word right to carry on any business will include the right to carry on any business unless there is a specific law banning it. That means there should be a specific law saying you can't do gambling, the specific law saying you can't do this or you can't do that activity. That was put up by 19(1)(g), saying that everything is permitted unless it is specifically prohibited. This was turned down by Justice Das on the ground that, look, the word business in Article 19(1)(g) and similarly trade and business in Article 301, which talks of freedom of trade within India, will not include activities which are res extra commercium. Business necessarily means a legitimate business. It need not be banned. If society over the years has treated some activities like alcohol and prostitution and gambling and so on, there need not be a specific, there's no right to do these activities. A specific ban is not necessary. Now, it was in that context that the Supreme Court referred to certain passages. Now, in my submission, RNDC 1 is a clear authority for the proposition that entry 34, when it uses the expression betting and gambling, refers only to games of chance. Games of skill are outside the scope of entry 34. That's a very clear proposition. And I'll just give an extract of this in the next slide. Please see the next slide. Now, this is from RNDC 1. So if you just see what it says, it said that initially it was felt that the chance should be 100%. Even a small amount of skill is required, it will not be treated as gambling. But now they agree with Chagla's view and say that this is too extreme a view. There should be a substantial degree of skill. And see the underlying portion. It will suffice to say that we agree with the Court of Appeal that a competition to avoid the stigma of gambling must depend to a large, substantial degree on the exercise of skill. Therefore, a competition success wherein does not depend to a substantial degree on skill is now recognized to be of a gambling nature. So, fair and square on entry 34 list 2, they have said once there is skill, it cannot be treated as gambling. But the present judgment says even if there is skill, once you put a stake and the future is uncertain, I mean, every game is future is uncertain, otherwise it can't be a game. So here they said, once there is skill, there is no gambling. So to that extent, it's my view that the present judgment may not be correct. Now, interestingly, 2 or 3 points. The Supreme Court says, refers to certain passages where Justice Das has referred to the Rig Veda, to Yajnavalkya, to Brahaspati, and to extracts from Hamilton's Hedaya. Now, interestingly, these are all passages which don't say that gambling is there, because the reference is made that staking on chess also is a vice. So the Supreme Court says that if staking on chess is a vice, that means Supreme Court accepted that even placing a stake on skill is gambling. But in my view, that may not be a correct reading. These passages were used by Das in the context of Article 19(1)(g) to say business must mean something which is legitimate and which is not res extra commercial. Activities which are frowned upon by society, nobody can claim a fundamental right to do such an activity. That's what it says so. And interestingly, they refer to Hamilton's Hedaya, where he refers to chess and dice and placing stake is wrong. But Hedaya actually is a 12th century commentary on Hanafi law. There, one chapter refers to chess and dice, but there is another part which says that placing stakes on camel racing, horse racing, and archery is permitted because, according to the Prophet, these are necessary for martial preparedness. So there is no universal thing that just because it's a chess or skill, it amounts to gambling. No. So these judgments, these religious texts also cannot be used to determine the scope of entry 34, particularly because it was used in the context of what is a business and not whether it is a betting and gambling. Now, please come to RMDC 2. Very interesting part of RMDC 2. Why do I say RM? Interestingly, both judgments were delivered on the same day, 9th May 1957. According to CY, this is one of the classic judgments which has discussed the doctrine of severability. Mr. Palkhiwala argued this case, RMDC 2. Now, what is RMDC 2? The first RMDC was an appeal against Chagla's judgment from the Bombay High Court. Now, when Justice Chagla's judgment was an appeal and the matter was pending, there is a special provision under Article 255 of the Constitution where even if a subject is in the state list, states can request, 2 or more states can request Parliament to pass a law. So, here one second. Yes, Article 252. Power of Parliament to legislate for 2 or more states. So what happened was about 8 or 9 states, that is Mysore, Bombay, Madras, and some other states, they all got together and requested Parliament to make a law with regard to prize competition, which is betting and gambling. So Parliament could not have made the law but for the request made under Article 252. So we have the Prize Competitions Act of 1955, which is a law relating to betting and gambling, a state subject, but made by Parliament on the special request of the states. This law, again under Section 2D, defined prize competitions to include crossword puzzles and so on and so forth, and it made a total ban about all these competitions. So all prize competitions were banned. This was challenged by Chamarwala directly under Article 32. And this writ petition was heard along with the appeal from Justice Chagla's judgment. Now, in this writ petition, a very interesting, the section was a total ban. No restriction or no distinction between skill and chance. Mr. Palkhiwala argued that if the ban is to include games of skill, it will not survive constitutional challenge. So that section 2D, which had a ban on all competitions, must be struck down. He argued that if it's a game of skill, it is covered by Article 19(1)(g). It's a legitimate business activity. Very interestingly, Mr. Sirwai, who appeared for the state of Bombay, agreed that there cannot be a ban on games of skill totally. It would violate Article 19(1)(g). It would not be a reasonable restriction. But he requested the court that the whole section need not be struck down. You can apply the doctrine of severability, and 2D, which was a ban on competitions, could be split and made applicable only to games of chance. So it was very, very clear that games of skill will not come in terms of entry 34 of list 2. You cannot ban them. At the most, you can regulate them, and they are protected by 19(1)(g). Now, this is what RMDC 2 has held, that please see what I've said. On gambling, you can't get the protection of 19(1)(g). Please see the underlying portion. As regards competitions which involve substantial skill, different considerations arise. They are business activities, protection of which is guaranteed by 19(1)(g). The question is, so to say that once a bet is placed, there is no difference between skill and chance, everything amounts to gambling, may not be a correct view, is my submission. This also will be an important ground of challenge in the new parliamentary law which bans online games, where if the online games are games of skill, then you can't ban it unless there is a constitutional amendment itself. Unless you make an amendment to the constitution, you can't ban it. Now, please, so in 1955, that is 70 years ago, the court categorically, unequivocally made it clear that games of skill is as legitimate as any business activity. They cannot be banned. But if it's a game of chance, different considerations arise, they can be banned. These two judgments were followed by the Madras and Karnataka High Court. But the Supreme Court has now said, no, these two judgments are to be distinguished because they are on different facts, and entry 34 of list 2 did not strictly arise for consideration. So the new view is that these two judgments don't apply. In my humble submission, that may not be a correct view. It may require reconsideration, is my humble view. Now, it doesn't stop there. Fast forward to 1968. Go to the next slide. Before I deal with this case in 1976, in the case of Shankar Narayana, which came from Andhra Pradesh, Satyanarayana, which came from Andhra Pradesh, the question arose whether rummy is a game of skill. The Supreme Court said, yes, rummy is a game of skill, and they further held that rummy cannot be banned because of the Public Gambling Act of 1867. Once it's a game of skill, there is no violation in playing rummy even if stakes are involved. And in that judgment, there is also reference to the placing of bets while playing rummy. They said it is perfectly legal. Now, this Madras High Court judgment is very, very important in the context of what I'm saying. What is the view of the Supreme Court now? That moment there is a bet, the moment there is a stake, it automatically amounts to gambling. In 1976, the Madras High Court was concerned with a law which sought to place a ban on horse racing. This was challenged by the Madras Race Club before the Madras High Court. The High Court upheld the ban. They said, yes, horse racing is bad. And this is what the Madras High Court says. Please see, the second line is very important. Every betting by itself is a gamble, involves an element of uncertainty. What the Supreme Court says, the moment there is a bet and there is an uncertain event, it is amounts to gambling. Where there is betting, there is gambling. Where there is a gambling by hazarding money on uncertain event of winning on a horse, there is betting. Betting is gambling, and gambling includes a bet. Betting. It follows, therefore, whether the entry is betting or betting and gambling, the effect and power is the same. So they said, once you place a bet, they didn't bother about it's a game of skill or game of chance, it amounts to. This is the view taken by the Madras High Court. Now, the race club filed an appeal. Another party, Lakshmanan, filed an Article 32 petition challenging certain provisions, and this came before the Supreme Court much later in 1996. Please come to this. Lakshmanan's case. Next slide, please. See, now, the court, therefore, in the two Chamarbagwala case, has said gambling is not trade and not protected by 19 It has been authoritatively held that competitions which involve substantial skill are not gambling activities. Now come to the last paragraph. We allow the writ petition and the writ appeal. The impugned judgment of the High Court is set aside. So the view of the High Court that once there is betting, there is automatically gambling was expressly considered by a three-judge bench and has been held to be bad. They have made it very clear. And please see second paragraph. The two Chamarbagwala case and Satyanarayana case, once there is a degree of skill, it cannot be gambling. So my humble view is that to say that just because there is a bet and there is uncertain event, it will amount to gambling is not correct. The distinction that these cases are with an organized sport and so on also may require reconsideration. Whether it is prize competition, a crossword puzzle, or a horse race, or rummy, across the board, the common factor is that this acid test is what is being played a game of skill or a game of chance. If it is a game of skill, it cannot be banned. Secondly, it cannot become betting and gambling. That is the law laid down, but the present judgment has taken a different view. Now, please come to the next slide. So with this, my view is that the persons playing online games, wherever it is a game of chance, it can be regulated, it can be banned, it can be permitted like a casino. Some states can permit casinos. It's not that it is automatically disallowed. But if it's a game of skill, it cannot be totally banned. It cannot be part of betting and gambling. Now I come, so with that I conclude my talk on the constitutional aspect. Now let me come to the GST aspect. In GST, the definition of goods includes actionable claim. This is very peculiar because the Sale of Goods Act expressly says that goods don't include actionable claim. Now, actionable claim, so most of you know in Section 3 of the Transfer of Property Act, actionable claim is nothing but an unsecured debt which can be enforced in a court of law. If it is secured either by a mortgage, etc., it will not be an actionable claim. So, actionable claim means you have sold some goods to somebody, they owe you money, it's an actionable claim. You have given money on a security or on some hypothecation, it is not actionable claim. But if it's a pure debt, that debt can be future, it can be contingent, it can be other. But if it's a debt which can be enforced in a court of law, it's an actionable claim. It follows that if your contract is against public policy, it will not be enforceable in law. So actionable claim is nothing but a debt. In Sunrise, the Supreme Court said that lotteries are actionable claims. Now, to get over that, the definition in the GST says goods include actionable claim. Now, Parliament can create a legal fiction. There's nothing wrong with that. So they say good includes actionable claims. At the same time, to levy a GST on a debt would be disastrous because every contract will involve a debt due. And if you start taxing that, it will lead to absurd consequences. So what they did was in Schedule 3, they said there'll be no supply either of goods or of service in the context of actionable claims. But they excluded horse races, lottery and betting and gambling. Lotteries, betting and gambling. So what they said was, if it is betting and gambling, then GST can be levied. Now, what is the scope of betting and gambling in Schedule? It should be Schedule 3. It's a mistake in the typo. It's a Schedule 3. So used to Constitution, I put Schedule 7. It's Schedule 3. Schedule 3 is betting and gambling. Now, in the light of the Public Gambling Act of 1867, which was preceded by an 1855 Act, RMDC 1, RMDC 2, Satyanarayana, Lakshmanan. The law is very, very clear that no GST can be levied on betting and gambling if it's a game of skill. So there the tax cannot be levied. But show cause notices are issued taxing everything, whether it's a game of skill, game of chance. That's how writs were filed, and Karnataka High Court, the court quashed those show cause notices, which now came to the Supreme Court. Once the Supreme Court took the view that if you place a bet or a stake and there is uncertainty, it amounts to betting and gambling. Once you take that view, then the distinction between game of skill and game of chance is completely blurred. Now, any online game will be taxable. The moment there is a entry fee or a stake or a bet, it will be taxed. So the challenges to the show cause notices was rejected. The Karnataka High Court view was reversed, and now the parties have to argue on. I must add that in the judgment, you will require further consideration because at different places they've used the word entry fee, they've used the word stake, they've used the word outcome of a contingent nature, pre-declared prizes. So there are some points of ambiguity which I cannot go into now because of lack of time. I'm going to confine myself to the very important point which the Supreme Court has laid down by treating certain rules as being retrospective, certain amendments being retrospective. Because of these huge demands of astronomical amounts, the matter was taken up with the ministry. The 50th and 51st GST Council was taken up. And the main problem was, can you start taxing every bet at 28%? Then it just goes in geometric progression. So it was decided that there will be a completely new scheme where only the first deposit will be taxed at 28%, and all subsequent individual bets or whatever you do will not be subject to GST. Then whatever you win will be subject to income tax, but there will be no GST on bet after bet. Now, to do that, what Parliament did was, based on the recommendations of the 51st GST Council, they made an amendment in 2023 to the CGST Act. Now the question is, are the amendments retrospective? Are they clarificatory? And therefore they'll operate from the beginning. The Supreme Court has said the amendments are clarificatory. They only bring specificity and clarification to the earlier position. My humble view is these amendments cannot be taken as retrospective. We argued that from 1/10/23, when the law came in, we are all going to pay tax on 28% on the wallet. But before that, the earlier law was to place a thing on every bet. And one additional thing was under Rule 31A, very cleverly, what the government did was they said tax on betting, gambling. And we argue that, look, the constitutional phrase is betting and gambling. You can't take betting separately, gambling separately in a rule. Unless you amend the constitution, you can't make these changes in the act and the rule. Therefore, you can't separately say that every bet I will tax. You can tax the bet only if it comes in the category of betting and gambling, which is game of chance. That was the challenge to 31A. So, prior to October 2023, games of skill could not be taxed because the schedule in the GST must be in accordance or consonance with the Constitution. You can't have the GST in variance or in contradiction with the Constitution. Now, this law was amended to rectify this defect, and what they did was they created a new category of online money game under 80B. And they said, we will tax an online money game, whether it is a game of skill or game of chance. So no longer the category is betting and gambling, the category is online money game. This is a perfectly legitimate way of taxing an online game. It can be game of skill because then you're not making the distinction of game of skill and game of chance. You're taxing an online money game. Then they define online game, money game, specified actionable claim, supplier. The point I'm making is it required amendments to several statutory provisions. It required replacement of the schedule, and new rules were framed. Now, once the new rules are framed, according to me, the whole scheme shows that a new method of taxation has come into place, which cannot be retrospective. And I'll come to the next slide. Yes. Why do I say it can't be retrospective? First, if you see the statement of objects and reasons, there is no mention that it is intended to be clarificatory or declaratory. Secondly, typically any clarificatory amendment will have the words for the removal of doubts. Or if it is not there, then you see the section or the amendment in the context of what was the law before, what is the law now, and whether the new provision is only making clear what was there earlier. Or, to put it simply, a clarificatory amendment is where what is implicit becomes explicit, or there is a need for clarification to avoid absurdity, to avoid a unworkability of the statute, so you make an amendment. Now, Supreme Court has relied on some cases. In all these cases, only one particular section in that particular judgment has been amended. For example, Vatika Township, Section 113 of the Income Tax Act, a proviso was added. You take another case, a proviso added, a subsection is added, and so on. But there is no case where there's an amendment act involving changes in 6-7 statutes, rules, schedules, etc. Now, to call that clarificatory, in my humble submission, may not be correct, because tomorrow we should stick to the earlier law that if you want to call it retrospective, then it must be something which the earlier law contemplated. Now, please see the next part. I'll come to the why it's not retrospective in working later, but see this. Other point is there is a very unique provision in the CGST Act which enables rules to be made with retrospective effect. Now, if Rule 31B and 31C was to be retrospective, they could have done so. They've done it for Rule 89.5, that is there in VKC footwear, it's been upheld on input tax credit. But 31B and 31C is, the amendment says it is on 29/9/2023 with effect from 1/10/2023. So the amendment itself says it's from 1/10/2023. Therefore, my humble view is once Parliament or the rule-making body has made it clear that this rule takes effect from so and so day, it can't be then called clarificatory and made applied to a past period. Also, the general rule is, as a general rule, delegated legislation can never be retrospective unless Parliament makes it so. For example, those of us practicing earlier days in J.K. Cotton, there was a doubt as to whether you can levy excise duty on captive consumption because excise duty was when the goods left the factory. They tried to levy excise duty on captive consumption at the intermediate stage. So Caltex, they said that, look, the section says excise duty is on removal from the factory. If there is no removal, then there can be no duty. They amended Rule 9 and 49 of the Central Excise Rules 1944 to say captive consumption shall be deemed to be removal. But Section 51 of the Finance Act of 1981 said these rules shall take effect from a retrospective date. So unless a rule is made retrospective by a statute, it can't be. The third reason why it should not be retrospective is the GST Council. If you see the minutes of the meeting, there is no indication that it required clarification. In fact, there is a GST Council, the 50th meeting, which met and they deliberated on this. There was a special report of the group of ministers on casinos, race courses, and online gaming. And they mentioned that it should be taxed at 28% on the deposit and not on every bet. Then 51st Council meeting, they recommended some further changes. So in the light of GST Council meeting, there is no indication that they wanted these provisions to apply retrospectively. Now, most important, why it can't be clarificatory is, my view is, there is a complete change in the taxable event. From taxing every deposit, from every bet, you have gone to taxing the deposit at once. So there's no multiple taxation. Earlier, the taxation was on 100% of each bet. Now it's on the total deposit. It's a one-time tax. So the taxable event has changed. The valuation has changed. In the light of all these changes, I would say that it may not be correct to call it a retrospective nature. Therefore, friends, I have come to the conclusion. I have come to my end. I have explained why we should maintain the distinction between game of skill and game of chance, and why these amendments should not be retrospective. A law which was there for 70 years has now changed, and now just placing a bet will make everything a gamble, which in my view is contrary to jurisprudence of 70 years. But this is the new law and we have to respect it and welcome it. Thank you so much.
Yeah. So can I take a couple of questions? Is it possible?
Yes.
Yeah. So Nishan Mundada is asking whether any review petition is likely to be filed.
I'm told some of them may file, but I'm not very sure because as a senior counsel, nobody has. But some people may file.
Yeah. And okay.
But in my view, it's a fit case for a review.
And if your review fails, then of course there is an option for a curative, right, sir?
I don't know if a curative will lie because Supreme Court may take a correct view or wrong view, but a curative will lie only where there is absence of natural justice or there is irretrievable failure of justice. One point here is that the Supreme Court could have clarified that Section 74, that is, there will be the allegations of suppression, etc., will not be made because once there's suppression, then there is chances of penal consequences under Section 122 and the criminal sections apply. So one point which requires clarification is they should make it very clear that if you're saying that the new law will apply retrospectively, obviously you can't accuse the SSCs of suppression, willful default, fraud, etc.
So in Bharti Hexacom case, you successfully pleaded with a bench led by Justice Nagaratna that the doctrine of prospective overruling should apply, so on. So so in this case also, you think you can make a similar plea that the judgment should apply prospectively vis-a-vis the
No,
retrospectivity.
actually, this application of 31B retrospectively was not a main issue, it's an argument at all. What we argued was the new law takes effect from 31B, which should be from 11023, and all of us were paying duty. In fact, government is collecting 18,000 crores per year in tax. By virtue of the new amendment, the collection had gone to 18,000 crores per year on gaming industry alone. And many people had invested monies, people were being employed. What we objected was under Rule 31A3, don't place a tax on every bet. Before 23, you can't split betting and gambling separately. You'll have to tax only games of chance and not games of skill. And other issues are actionable claims. See, first of all, an actionable claim, when does an actionable claim arise? All those complicated issues were there, but that's not relevant. My point is, this law should have been prospective, and the earlier period, they should have taxed only games where there's a game of chance in accordance with the earlier provisions.
Okay. Uh, I have quite a few. I'm just selecting. Here is one from Mr. S. Raghunathan.
So I just see we can go through them quickly if you want.
No, sir. I'll just take couple more because there are quite a few. Mr. S. Raghunathan says in all endeavors, including businesses, there is an element of chance of success with stakes, assuming character of stakes. Hence, the recent judgment may need review or guardrails to protect different business activities. Your view, sir?
Yeah,
Mr.
in fact,
Raghunathan,
some people have told me, what about person who's what do you call trading in shares? Will
yeah.
that amount to a gamble? Because he's placing a stake or on this thing, and it's an uncertain event. He's right, that could lead a point. But this was in the context of online games. So we can say that in the context of online games, once there is a stake, there'll be a gamble. It may not extend to normal business activities. Or other cases where there's everything is uncertain. In fact, what will happen tomorrow for you and me also, we don't know. So everything is uncertain. Here, the point was, earlier law was, uncertainty is not the issue, consideration not the issue, skill or chance is the issue.
Okay. Okay. Sir, can I take a couple more questions?
Yeah, I'm free. You
Okay,
can take it.
fine. Ashish Chaudhary has many questions, but I'm taking one of them. Can the concept of an actionable claim, as interpreted in this judgment, be applied to the activity of extending a corporate guarantee to a related person?
Well, one thing is, forget about this case. If there is a corporate guarantee, guarantee, there's a principal debtor and there is a guarantor. If the principal debtor has defaulted, the guarantee kicks in. That does give rise to an actionable claim. So, irrespective of the judgment, in a corporate guarantee, it will lead to a actionable claim under Section 3.
Okay. Vijay Gupta is asking, sir, how to distinguish between game of skill and gambling. Playing card would be game of skill or gambling, and if the response would change if there is a prize to win for the winner. I think this was adequately argued during the case itself.
No, not only that, in fact, there's no time, but there are judgments which are given 4 steps of what is skill, where 4 steps are involved. Lakshmanan's case, they discuss that. That is to say, you must have domain knowledge, experience, expertise, like in fantasy sport, like Dream 11 and so on. I didn't want to discuss on fantasy sport. Fantasy sport was started by some Harvard professors who made their teams from pending players. Now, fantasy sport has to be linked to an actual. When IPL is there, they can be fantasy sport. Once IPL is over, you can't have a fantasy sport for IPL because it has to be linked to an actual match. And then you apply your knowledge of basketball or football. Today, FIFA, there's a huge fantasy sport on FIFA where you make your own teams based on the players' rules and regulations, and then you work on the outcome. So there is great element of skill because if you don't know who are the players, you may just know Lionel Messi or somebody else, but unless you know the actual players, the bowlers, the pitch, so it's very, very fascinating. People who have deep domain knowledge only do much better statistically. The greater your skill in knowing cricket, for example, will give you a better chance of winning, of getting a prize money in this thing. And in fantasy sport, there is no stake. It's an entry fee. You enter, there is a predetermined price, and depending on, suppose the first prize is 1 crore or 10 lakhs, and there are 600 winners, get the same number of points, they will divide that prize money. So game of skill is well defined. And game of
Yeah.
chances, it's, as you know, your skill is irrelevant. Your knowledge is irrelevant. Like a roulette or a blackjack or, yeah. For
Yeah.
example, flush in cards, rummy and bridge is skill, but a teen patti, as they call it, is pure game of chance.
Yeah. Yeah. One comment. This is Siddhant Satya. He's actually asking a question. Prediction markets like poly market can also be clubbed under betting and gambling. By the way, the prediction markets have become very big in the US. So there would be someone
I don't
even
know what's the
predicting.
prediction market.
There was one repetition dealing with prediction market in this batch. I don't know what happened to that.
My friend told me there's one repetition on prediction market. I don't know what's the prediction market, but
Yeah.
by this test, if there is a stake or a amount placed, it's an uncertain event, then it is the gambling.
So, for example, sir, I may predict for how long your talk will last today.
No, see, that is that second part of RNBC 1, prediction of future event. In fact, I was told that there could be simple bets like the old Matka system in Bombay, whether it will rain tomorrow, whether something will happen tomorrow. They could just be simple event and people betting on that.
Yeah.
And in fact, cricket also, the unlawful betting, the earlier betting was whether he will bowl the next over, or there could be people continuously betting on whether the person will get out in the next over or not.
Yeah.
That is pure chance. And your no skill is required.
Yeah, fair point, sir. Sir, I can't take all the questions. There are some 15 more questions, 18 more questions that have come. So, sir, you please advise, should we close this? I may want to take one more from NR
So,
Badrinath.
see, I got my next meeting at 6:15. You can
So,
go
so
on.
so maybe couple more. That's it, sir. We'll
Yeah,
close
because
it.
see, people have listened for so long, they want to.
Yeah, two more. One, NR Badrinath. Now, how would this apply to normal clubs where there are card rooms?
Yes, there is an observation that will apply to online, offline. But in my view, as far as local clubs are concerned, they'll be covered by the Public Gambling Act, where skill is involved. Then, for example, Madras Police Act, rummy, etc., bridge can be played in clubs. It's perfectly valid because the Public Gambling Act doesn't prohibit games of skill. And the judgment also notes that these are only for the purpose of avoiding prosecution and penalty. It has got nothing to do with tax. So clubs can continue to play rummy, bridge, whatever they want. That will be fully permitted.
Yeah.
And I'm told most clubs, they don't permit teen patti or flush. They permit only rummy and bridge games of skill. It's very clear. I checked when I did this case that they don't allow card games of chance. It has to be bridge or rummy.
Okay. Sir, there are a lot of questions on what would be the consequences of this. Like you said, derivative trading. Someone is asking what would be the fate of litigation funding. Someone else is saying what about state lottery and so on and so forth. So I think over the next few months or so, we will see how this judgment will be interpreted by
Actually,
various stakeholders.
I'm grateful. I've never thought about this question of third-party funding in cases, which is, I assume, huge importance in today not permitted in India because of champerty and all that, but derivative trading, for example. So many issues may be affected. But the only thing is, suppose derivative trading is specifically permitted under SEBI regulations, hypothetically, then it can't be called as a gamble because it is subject to certain regulations, rules, and regulations.
Yeah. So many thanks for this wonderful exposition. An absolute pleasure to hear a counter view on the Gamescraft judgment. Last week we heard ASG and Venkatraman. This week we heard from senior advocate Arvind Datar, legal constitution titan. Pleasure, sir, and we all look forward to your new book on the
Yes.
on your third edition of your commentary on the Constitution. Can't wait to read it, sir.
And Arun, let me thank all the participants who took their time out to listen to this. It's
Our pleasure, sir.
a privilege. Thank you so much. All the best to all the participants.
Thanks, sir. Thank you, sir.
Goodbye. I'll sign off.
Goodbye, everyone. Have a relaxed weekend. Thank you.
Have a nice weekend. Thanks.
Yeah.